A US court explained the Functus Officio Doctrine in traditional terms as follows. The term is Latin for office performed, and in the law of arbitration means that once an arbitrator has issued his final award, he may not revise it. The Functus Officio Doctrine is distinguished from an arbitrator's premature resignation or removal. The term Functus Officio refers to a tribunal's completion of its mandate at the end of an arbitral proceeding by making an award with res judicata effect. In contrast, the resignation or removal of an arbitrator refers to the withdrawal of an individual from the tribunal before he or she has completed his mandate, with both the tribunal and the arbitral proceedings continuing.
At this point, many of you may be thinking that expert determination looks a lot like an arbitration. We have resolution of disputes outside of courts. We have resolution by a subject matter expert in the same way that arbitrators in the past were typically subject matter experts rather than lawyers. We have a degree of finality and limited scope for challenge, and we have a largely private process. The first difference is perhaps apparent during the course of the expert determination, and that is that the expert typically has much narrower powers than a tribunal would when conducting an arbitration. Experts are given a very narrow scope and a very narrow question typically to answer, whereas tribunals usually have jurisdiction to hear all disputes arising from or in connection with a particular contract. Similarly, there are differences between the powers that an expert and a tribunal have in order to conduct their work.
Article 34.2, subparagraph A, subparagraph 1 cites two jurisdictional grounds: the incapacity of a party or the invalidity of the arbitration agreement. The determination of a party's legal capacity, while not expressly provided in the model law, refers to the party's personal law. This refers to the legal capacity to enter into an arbitration agreement, and not the underlying contract which is subject of the dispute. The ground for invalidity of the arbitration agreement may be determined either by the law provided in the arbitration agreement or the law in the state before which the application is brought, ordinarily the place of arbitration.